Hello everyone, welcome to MAYANK LAWHOLIC. Today we are solving the DGS HGS paper of 2015. We have already solved the two papers of HGS examination of Delhi Judiciary. Please look into those papers in the respective playlist. Now let's get started. Question number 1. It was an agreement between the parties that no interest will be paid on the amount payable to contractor under the contract. Disputes and differences between the parties in accordance with the arbitration clause in the contract were referred to the arbitration under the Arbitration Conciliation Act 1996. The arbitral tribunal finds amounts to be due to the contractor and makes an award the said amount together with an interest at 24% per annum for the date of entering upon refers till the date of the award. The award to the extent of awarding such interest is liable to be set aside under section 34 of the said act, is not liable to be interfered with under section 34, is liable to be interfered to the extent of the rate of interest. Correct answer in this question is option 1. Is liable to be set aside under section 34 of the act. Section 34 of the Arbitration Conciliation Act 1996 talks about the application for setting aside of arbitral award. Now let us see the question number 2. The liability of the individual co-partner in a decree against a Hindu undivided family carrying business is to the extent of their share in the assets of the said joint Hindu family. This is the right answer. Now let us see the question number 3. A is entitled to succeed to an estate on the death of B. B dies C. Having received intelligence of B's death, prevents the intelligence reaching A and thus induces A to sell him the interest of the estate. Options are: the sale is voidable at the option of A, the sale is binding on A, the sale is voidable at the option of C, the sale is voidable at the option of A as well as C. Here the correct answer is option 1, the sale is voidable at the option of A. Now let us see the question number 4. A Hindu on 2nd January 2016 dies intestate, leaving a wife, 2 unmarried daughters and a son of his wife from an earlier marriage. His estate will be inherited equally with the wife, the 2 unmarried daughters and the son of the wife from an earlier marriage, each getting 1/4 share. Option 2, in 3 parts, with the wife and 2 unmarried daughters getting 1/3 share each and the son of the wife from the earlier marriage not getting a share. Option 3, only by the son of the wife from the earlier marriage, with the wife having a right of maintenance and the 2 unmarried daughters having a right of maintenance and married expenses only. Option 4, only by the wife and the son of the wife from an earlier marriage equally with the 2 unmarried daughters having only a right of marriage expenses at the maintenance. In question number 4, the correct answer will be option 2, in 3 parts, with the wife and 2 unmarried daughters getting 1/3 share each and the son of the wife from earlier marriage not getting a share. A mortgager in possession of a mortgaged property is not entitled to make a lease thereof. In the absence of a contract to the contrary, is entitled to make a lease thereof, binding on the mortgagee, provided the lease is made in the ordinary course of management of the property at best rent that can be reasonably obtained, does not contain a covenant for renewal and is for a period of less than 3 years. Option 3, can make lease thereof binding on the mortgage on whatsoever terms he desires and for whatever period. Option 4, is entitled to lease out the same only if expressly permitted to do so under the mortgage deed. Option 2 is the correct answer. Now let us see the question number 6. A sale of immovable property without payment of entire sale consideration to the seller is no sale, is void, is valid, and the seller has a charge upon the property in the hands of the buyer for the amount of the sale consideration remaining unpaid and for interest thereon, is a lease, is voidable. Correct answer is option 2, is valid, and the seller has a charge upon the property in the hands of the buyer for the amount of the sale consideration remaining unpaid and for interest thereon. Question number 7. A decree for injunction is not obeyed, is not executable by the detention of the judgment debtor in civil prison or by attachment of his property or by both, and also by directing the act required to be done at the cost of the judgment debtor, is executable by filing a petition under the Contempt of Court Act 1971, is executable by filing a fresh suit. Here the correct answer is option 2, is executable by detention of the judgment debtor in civil prison or by the attachment of his property or by both, and also by directing the act required to be done at the cost of the judgment debtor. Now let us see the question number 8. The period of limitation for filing a suit for the compensation for defamation is 3 years from the date when the defamatory words are published or spoken, is 3 years from the date when the plaintiff learns of defamation, is 1 year from the date when the defamatory words are published or spoken, is 1 year from the date when the plaintiff learns on the defamatory words having been published or spoken. Here correct answer is option 3. Now let us see the question number 9. A decree for restitution of conjugal right is executable by the attachment of property and by detention in civil prison, or by both, by attachment of property, by imprisonment, by granting a decree for divorce. Correct answer is option second, by attachment of property. Contingent agreement to do or not to do anything if an impossible event happens is voidable at the instance of the party who did not know the impossibility of the event, is void only on establishing that the impossibility of the event was known to the parties to the agreement to sell at the time of making the agreement. Option 4 is voidable at the instance of the either party. Correct answer is option first, is void. Contingent agreement to do or not to do anything if an impossible event happens is void. Question number 12. A person dispossessed without his consent from an immovable property otherwise than in due course of law can recover possession thereof, notwithstanding any other title that may be set up in such suit. Options are: if the suit is filed within 3 years from the date of dispossession. Option second, if the suit is filed within 12 years from the date of dispossession. Option third, if the suit is filed within 6 months from the date of dispossession. And option 4, if the suit is filed within 1 year from the date of dispossession. Correct answer is option third, if the suit is filed within 6 months from the date of dispossession. Contract, the performance of which involves a performance of a continuous duty, is not specifically enforceable only if the court cannot supervise such performance, is specifically enforceable, none of the above. Correct answer is option second, is not specifically enforceable only if the court cannot supervise such performance. Question number 14. The grant of refusal of temporary injunction under order 39 rule 1 and 2 of CPC is governed only by CPC, is governed by CPC as well as by the provisions of SRA, which with respect to injunction is not governed by the provisions of SRA as they are applicable, or grant of permanent injunctions and not to temporary injunctions is governed only by the principles of natural justice. Here the correct answer is option second, is governed by the CPC as well as by the provisions of Specific Relief Act 1963 with respect to injunctions. Question number 15. A notification to the Government of India is proved only by examining the concerned officials of the Government of India, only by obtaining a certificate from the press in which the same has been published or publication thereof, by producing before the court the printed copy thereof. Option 4, only by calling the Secretary of Government of India along with the original notification. Here the correct answer is option 3rd, by producing before the court the printed copy thereof. Question number 16. The terms of a contract reduced in the form of a document can be proved only by providing the document itself. This is the correct answer. Question number 17. A money bill under section 109 of the Constitution of India shall not be introduced in the Council of States, is the same as any other bill after it has been passed by the House of People, shall be transmitted to the Council of State, its recommendation, and House of People may thereupon either accept or reject all or of the recommendations of the Council of State. And option 4, both first and third. Correct answer is option 4. First is also correct, third is also correct answer. Question number 18. The directive principles of state policy enshrined in the Constitution of India are enforceable by the courts, are not enforceable by the courts, are enforceable only by the high courts, are enforceable only by the Supreme Court. Correct answer is option second, are not enforceable by the courts. Question number 19. The Election Commission of India has been constituted by the Parliamentary Act, is a society registered in the Societies Registration Act, and is an autonomous body of under Government of India, has been established by the Constitution of India, is a part of government thereof. Correct answer is option 3rd, has been established by the Constitution of India. Question number 20. The power of High Court under Article 226 of the Constitution of India extends all over the territory, extends throughout the territory in relation to which it exercises jurisdiction, extends throughout the territory in relation to which it exercises jurisdiction, and to the National Capital Territory of Delhi. And option 4, extend only to the city in which it is situated. Correct answer is option second, extend throughout the territory in relation to which exercises jurisdiction. An arbitration agreement is necessarily required to be in writing, may be oral, may be contained either in documents signed by the parties or in communication exchanged by the parties or by way of an admission. Both first and third option. Correct answer is option 4, both first option and third option is right. Question number 22. While a Hindu wife is an heir of her husband in the event of intestate, a Hindu husband is an heir of his wife in the event of intestate only if there are no sons and daughters, including children of predeceased son and daughter. The statement is true or false? This statement is false. Now let us see the question number 23. A child born of a marriage which is voidable under section 12 of the Hindu Marriage Act 1955, but before passing of a decree declaring its nullity, has a share not only in the properties of his father but will also have a share out of the share of his father in the ancestral properties. The statement is false. Question number 24. Certain amount was due to erstwhile Department of Telecommunication DOT of the central government from the subscriber for providing telephone connection for the year 1992 till its disconnection in the year 1998. In the year 2000, all the assets and liabilities of the DOT were taken over by BSNL incorporated under the Companies Act and 100% shares which are owned by the President of India. BSNL filed a suit for the recovery of the said dues from the subscriber, claiming that it is an agency or instrumentality of central government and that the benefit accrued in the favor of DOT of the central government as provided under Article 112 of the Limitation Act would stand extended to BSNL. Whether BSNL is entitled to benefit under Article 112 of the Constitution of India, that is, of a period of limitation of 30 years to institute a suit. Options are yes or no. Correct answer is no.